Good afternoon, everyone, and thank you for joining the Stringer LLP COVID-19 webinar, Lessons from the HR Trenches. My name is Ryan Conlon, and with me is my friend and partner, Jeremy Schwartz. We're going to be taking you through some of the lessons we've learned from COVID-19. This pandemic obviously started more than 5 months ago, back in the spring, when the snow was back on the ground in March 2020. A lot of uncertainty was out there as to what this was going to look like. Even uncertainty is whether we'd still be talking about this in what's almost August of 2020, but we are. And so what we're going to try to take you through in the most efficient manner we can is a whole gamut of issues that arise out of COVID-19. We're going to touch on occupational health and safety, which perhaps takes on a more preeminent role than it ever has. We're going to look at issues in relation to the Employment Standards Act and wrongful dismissals and how that's affecting litigation on those issues. We're going to touch on this current status of the various government programs that have arisen under COVID-19, some of which are winding up, some of which are going to continue through the rest of the year, and how they interact with other government programs like work sharing. And lastly, we're going to take a look at some human rights law issues in terms of privacy and in terms of accommodation issues that are triggered as they relate to return to work. Jeremy and I both believe that these presentations are most effective where you are asking questions, where people get an opportunity to ask questions. The slide's not advancing, Jeremy. So, yeah, well, welcome to the reality of COVID. We have technical difficulties. Anyway, so how to ask a question? Some of you, if you've been on our programs before, it's the same software. Type your question in the field blocks below and click send. It will be added to the queue. Next slide.
It should work again. Try it now.
Let me try it again. Yeah. That's an NO on that one. So.
Great.
If the question field's not expanded, just to look, all you have to do is press the plus symbol to the left of the header questions. Next slide. And if you cannot see the question box at all, you're going to see at the top right of your screen a little orange arrow. Just click on that, and it'll open up. All right, so this is your pandemic HR response plan. So we want to thank everyone who took the time to fill out the pre-session survey that Jeremy put together. It's very helpful and will sort of give us a picture, at least in terms of this audience, of what different folks are doing. As you can see from the slide, these are all the issues that we intend on covering throughout the presentation. Next slide. All right, so we're going to start first with occupational health and safety issues that are near and dear to my heart. Taking a look at the survey, you can see what protocols have you implemented at the workplace, and certainly we can see obviously remote working where possible. Not surprisingly, a significant number of you are doing that. Mandatory temperature checks, there's something we're seeing certainly at airports and certain facilities. I walked into a hotel not long ago and there was a security guard right there with a temperature check. Making masks mandatory, which effectively, mostly by municipal bylaws across Ontario and across Canada, is becoming a pretty common issue, at least in indoor areas. It's pretty hard to enter anything these days without a face covering. Providing hand sanitizer, again, almost universal on that. So a good number of employers are providing masks, some are providing gloves, and a good majority, more than 60%, are doing rotating shifts. So interesting. So all the precautions that are being certainly not implemented universally, but certainly a number of them have been. All right, so when we talk about health and safety law, let's talk a little bit about there's not a lot of COVID-19 sections of the Occupational Health and Safety Act. It's not something, there's no pandemic provisions in the legislation. So what does that do for us? It means that the general duty clause applies, which as far as employers are concerned, that's section 25 sub 2 sub H. I saw some of you are federally regulated under the Canada Labour Code. For those of you, there's a similar provision in Part 3 of the code as well that essentially means the same thing, that where the law doesn't specify a standard, an employer is required to do what is deemed to be reasonable. And we certainly are aware, those of you who are in for our last seminar, that there's been some government-issued directives and guidance, which I'm sure most of you have had an opportunity to review, which is largely consistent with what's been done in jurisdictions across Canada. Next slide. If there were ever to be a prosecution under the general duty clause, the courts have said in other contexts, not dealing with pandemics, but in other contexts, that the employers are not required to take every perceivable precaution. And certainly we know from the COVID situation that that due diligence is all about management of risk. And unfortunately, the reality is that no matter what you do, no matter what precautions you implement, there's going to be some risk. The Crown bears the burden of proof to establish that a precaution is reasonably required beyond a reasonable doubt. Ontario courts have held that employers are required to exceed standards prescribed by legislation in some instances. But generally is no standards prescribed by legislation in this context. In this context, and certainly the Ministry of Labour can issue orders on this general duty clause to comply with what the opinion of the inspector is reasonable. Next slide. There's guidance from the Ministry of Labour, which has been published on their website for some time now. It's industry-specific guidance issued by the Ministry of Labour and the Safe Workplace Associations for return to work and mitigating the risk of COVID-19. What is new is a recent amendment to the Occupational Health and Safety Act, which is going to make it easier for the government to require organizations to comply with standards. Historically, in order for a standard to be referenced in the legislation, it had to be included by means of a regulation, which is frankly a very bureaucratic and political process. So there are, if you look in, like, for example, the construction regulations around fall protection or the diving regulations around certain issues, you'll see various CSA standards, Canadian Standards Association reference. But in Ontario, it has not been the historic practice of the Ministry of Labour to, and certainly hasn't been recently, having less standards added with the confined space regs that were added. Now, the Ministry of Labour is going to have much broader power to reference external safety standards and make them enforced as if they are part of the legislation. This is an important change that has been brought about as part of the broad, what government calls omnibus legislation, which means legislation dealing with all kinds of different issues, which is pretty common in COVID-19 if you look at the emergency orders. But that will have a lasting and permanent impact on employers. But in the meantime, the MOL will likely be using the general duty clause, and certainly that general duty clause will be referenced in any labor arbitrations or prosecutions that arise out of this. Next slide. So I have a scenario for you. We're going to go through a few of these just to see how the law sort of shakes out practically. This is going to obviously this scenario will accompany to deal with a lot of you. We saw from the poll that almost 90% of you are having people working at home in some capacity. So most of an employer's workforce is now working directly at home. An employee accuses a worker of harassing them during a Zoom meeting by engaging in unwanted sexual banter. I've certainly had some calls and comments from my clients that as people, are working from home and, quote unquote, working in their pajamas in their kitchen, that there's been, a little bit of a relaxing of the ordinary sort of, way people communicate. And certainly sometimes there's been a concern, well, what if someone, crosses the line at home? And certainly the Occupational Health and Safety Act carves out an express exemption for people working at home, or at least as it's phrased, that the act doesn't apply to work that's taking place in a residence. So is the employer then free to say, hey, the act doesn't apply, I don't have to investigate this complaint of harassment, at least or not follow the formal OHSA protocols? The answer to that question, I think, is an unequivocal no. There is one case from the Ontario Labour Relations Board that predates COVID-19, which dealt with this exact scenario, a sexual harassment complaint against a person who was working at home just as part of their job. And nobody raised the issue of, well, the act doesn't apply here because the person's working from home. I suppose a creative argument could be made to that effect, but I think it would be unlike the Labour Board. The act is supposed to be interpreted broadly and purposively, which in court language means let's stretch it to cover as much as it can possibly cover. So in that regard, it's my suggestion to those of you listening that I would not be concerning myself too much with these kind of exemptions. If someone files a harassment complaint online, treat it as you would any other complaint, just because it took place online. And even if the OHSA is, technically held not to apply to that scenario, you have human rights risks and litigation risks of various kinds if you don't do anything about it. But sometimes people, get themselves in a bit of a quandary about tying what the law covers and when it doesn't. I think it's important more to be practical than technical, which is always the best advice I can give when dealing with the OHSA. Not that the ministry always follows that advice, mind you. Next scenario is workers in a unionized healthcare setting take issue with the quality of PPE being offered by the employer. Labor negotiations are underway. the workers do not call the Ministry of Labor. So they don't, phone the Ministry of Labor. They don't run off to court, as some unions have done, to, get an injunction to get the court to handle it in cases that Landon and I talked about in our last webinar. But soon after the complaints start, lo and behold, an unusually high number of workers start to call in sick. The employer is forced to obtain workers from a staffing agency to cover the ground. And this is based on a real case. If you read the article that we wrote, we covered a case that was not an occupational health and safety case. It was in fact a case from the employer saying, hey, this is an unlawful strike. Like under labor relations law, there's very specific procedures that have to take place in terms of when a legal strike can take place. The collective agreement's expired and what's called a no board report has been issued. But you can't just, but if your workers are engaging in a concerted activity, they're not permitted to do that under labor law. And certainly in the case at the board, the union did what I thought was a very interesting tap dance, where they basically tried to, raise all these health and safety issues and discuss these as concerns without filing a formal complaint with the ministry and making it an actual part of the case. They were being a little too cute for their own good, from my perspective, and at least on those facts, the union was found to have engaged in an unlawful strike. Jeremy, I know that you covered this case fairly extensively. You actually spoke about it in front of a national audience of employment lawyers yesterday. I don't know if you have any thoughts you wanted to add on that.
Only that it would seem that the rules that apply to the adjudication of work refusals and unlawful strikes would seem to be the same. And so when you have employees, whether engaged in concert in like a sick-in, or they're engaged in a generalized work refusal in concert, there's the labor relations aspect of that if they're unionized. If they're not unionized, of course, then you just have a situation where everybody is asserting, officially or not, that they feel unsafe at work, and you handle it like you would any other work refusal with the same legal tools.
All right. So let's, I think it's helpful. I mean, again, I think that's really, and as Jeremy said to the audience yesterday, like we really, embarked upon really tried to see what kind of case law we could find nationally on the litigation of work refusal in this context. It just hasn't happened. So what does that tell me? Well, first of all, litigation is, it's moving more slowly in COVID. And secondly, it tells me that these issues are being resolved by other means, by settlements, or by just outright dismissals at the officer level that haven't been litigated. So there has not been a rash of hundreds of these kind of decisions that have gone as far as being litigated, which isn't to mean there isn't a lot of work refusals. I've dealt with a number of them. It's just they've been dealt with more administratively. Remembering litigating these matters on the part of a worker or a union is complex and expensive, and and sometimes complicated to be successful if the employer is following the law. But work refusals, workers generally have the right to refuse unsafe work to perform that they consider unsafe. Now, as I've commented before, this legislation is very old. It was written in the 80s, and work refusals were then contemplated in the 1980s economy, which in Ontario was largely unionized manufacturing. And so that was sort of the context that it was written, and hasn't been significantly updated since that time. It certainly wasn't written with a global pandemic in mind, or even with the concept of the idea that one could work electronically from home was but a vision of Steve Jobs at that time. So again, so we have to look at that the language of this legislation is somewhat limiting in terms of what workers can and can't do. There obviously are fairly broad exemptions. Some workers, which are the exemptions I think you would expect. These are workers in law enforcement. These are hospital workers. These are contractors associated with performing, essential functions in those kind of facilities. If there's a dispute about a work refusal, much like with the unlawful strike matter, it would be heard by the Labor Relations Board. And frankly, historically, where the body of 90% of those cases, maybe that's a slight exaggeration, are coming out of the correctional sector. That's where most of these kind of cases are heard. So ultimately, historically, there hasn't been a tremendous amount of litigation over this kind of issue. And a lot of the historic work refusal issues are usually, many times, that escalate as far as the board, are almost sort of labor relations issues that sort of go hand in hand oftentimes in unionized environments. Next slide. So this is the actual provision of the work refusal section of the Act. And look at the sort of, a worker may refuse to do work when any equipment, machine, device, or other thing the worker is used to operate is likely to endanger him or herself. Not likely applicable here in the pandemic. It's really B and D that matter. The physical condition of the workplace, or the part thereof in which the worker is likely to endanger himself, is a danger. Or lastly, that matters is for this purpose under sub C, any equipment, machine, or device or thing is in contravention of the act or regulations, and such contravention is likely to endanger them. I mean, again, the contravention's got to be failing to take reasonable precaution. So it's a fairly limited right that really specifically relates to the physical condition of the workplace. So even then, so it's not a carte blanche right to refuse to work for all things. I mean, I'm not. So I mean, again, that puts the worker in an uphill battle with the legislation not requiring specific things. But clearly, I think a blatant violation of the government's guidelines could certainly be an issue. Next slide. Employers must be, when you're confronted with a work refusal, this is the kind of strategy I think you must be prepared to respond to the work refusal with clear reasons why the work refusal is unfounded. That may very well be the most obvious reason is that we've looked at our sector guidelines published by the Ministry of Labor, that we're in compliance with them, that we have researched issues as they relate to these kind of matters. So I mean, that's the issue. One of the issues with a work refusal, though, is how it historically has operated. Is that it's kind of a two-stage. It's kind of a two-stage situation. Stage one is the employer tries to resolve the matter internally with the worker and the union. If they can't, then the Ministry of Labor gets involved, and the worker, quote unquote, does something else or waits in a safe place for that dispute to be resolved. Now, obviously, from a COVID perspective, that no one really it wasn't contemplated that someone would be, say, working at home and refusing to come to work at all. I think the section doesn't really contemplate that, but I think it's been permitted. What I can tell you, though, is that it's been our experience that the Ministry of Labor has just not been sustaining these work refusals. They've established a special committee within the Legal Services branch of the Ministry of Labor. So, I mean, typically, the Ministry of Labor is, if you're complying with the guidelines, there's not been an appetite on the part of the MOL or the inspectorate, for that matter, who quite frankly are probably not wildly enthusiastic about touring various workplaces in person if they can avoid it for understandable reasons, are trying to basically say, look, let's get in compliance with the guidelines here. They're not really digging down into the minutiae. For those of you sometimes who've dealt with them know that sometimes they can get to be very, very specific, and litigation can go on about very persnickety things about, for example, about what is a means of summoning on a window cleaning job, for example. But I mean, we're not getting that. It's more big picture things on this. Next slide. So, I mean, first of all, every time you get a work refusal, you want to pay attention to whether the purported work refusal is actually covered by the legislation. Is it really about the physical condition of the workplace or alleged violation of the regulations? Is the worker or the working question exempt? Like, is it actually covered by it? If you're a teacher, it's a different right. You have to make sure that what you're dealing with is not an even more limited right of work refusals. You want to involve the Joint Health and Safety Committee at an early stage with planning for return to work and to avoid work refusals. Be prepared for the employee who is initiating a work refusal to advance a labor relations agenda. That may happen sometimes when people are refusing work. In fact, there's something else going on. It may be a dispute with labor relations. It may be this in a non-union environment, this on person's personal issue about something. And ultimately, as I say, it may very well take a while to make a decision from the Ministry of Labor, depending on how it's being processed at the time it happens. I remind you that it's prohibited to engage in a reprisal against workers for exercising their rights under the OHSA. If a worker alleges they're exercising their rights under health and safety, it's a reverse onus. The employer has to prove that whatever decision was made. And again, the worker has to establish that something deleterious, that something happened to them, that there's some sort of consequence. It's not just a reprisal. It's not just that they have to show what that was, whether it was they were fired, they were demoted, they were assigned work that was less than desirable. It's not a huge threshold, but there has to be a consequence spelled out. Employers who are acting in good faith should not let a fear of reprisal application paralyze their decision-making process. If there's a piece of legislation that workers fundamentally misunderstand in Ontario, it's reprisals, right? It's actually a relatively narrow provision that was meant to prevent retaliation against somebody who was legitimately exercising a specific statutory right under the Act that they had, often whether it was to refuse work, whether it was to file a harassment complaint, like whatever it is. I mean, it's narrow. It's not a carte blanche way to complain about any type of unfairness that's been happened. And we see case law. We saw one the other day where an employee was named in a harassment complaint and somehow figured that was for reprisal and then just started to go after the employer for it. That's not what it was meant for. I should point out, though, that workers get free representation on these cases from the Office of the Worker Advisor, who has this, kind of practice. But I will say that it's been my general experience with employers that are acting in good faith that you shouldn't you know, you just want to exercise common sense. You're not going to like fire someone the next day after they file the safety complaint. But I have dealt with more than one case where employees are using safety complaints as a sword rather than a shield, and you shouldn't be afraid. The board can see through those kind of cases, in my experience. All right, so we move to some scenarios now. First one is a worker has been working at home since the start of the pandemic. The employer has decided she should now return to the office with all appropriate COVID-19 precautions in place. The worker states she does not think that the workplace is safe because the employer is not issuing any N95 masks. These are the fitted masks that are used in high-risk medical settings that there is a worldwide shortage of after COVID-19. These are the masks that were the subject of litigation brought by the Nurses Association before the courts, saying in high-risk nursing homes we didn't have enough of these, and there was a lot of toing and froing about that. But the employer responds to the worker in question, and this is like an office setting, that N95 masks are in short supply, and they have an opinion from an expert that that they are not necessary to safely prevent to reduce the risk of the transmission of COVID-19. They'd be ideal, but there's a number of factors that go into N95 masks. First of all, you can't get them. Second of all, they have to be properly fitted. The idea of a mask is to reduce, but certainly not eliminate the risk. So, if the Ministry of Labor got a work refusal on that basis, what do you think is likely to happen? I'm going to suggest what's likely to happen is one can never be sure, right? Because these are human beings and there's discretion involved. And frankly, who knows what the actual answer is? But I think I have a pretty good guess. Is that the Ministry of Labor is going to say, in this particular environment, you're not dealing with patients that have COVID-19. You're not in a medical setting. You're not in a high-risk setting of a nursing home where the disease, especially in the early days of the pandemic, spread like wildfire. That is, you don't have to take every perceivable precaution. A mask is a reasonable precaution, and a work refusal isn't justified in these circumstances. That's how I think it would go down, but I guess we'll have to see. So this is a very interesting statistic that comes out of our stuff. So 2/3 of you haven't had a work refusal, but 1 out of 3 of you who answered our survey has, and more than 90% of them were almost 90% of them were addressed internally. So I think it shows you that the way most of these are being dealt with, at least in this admittedly unscientific survey, is that that they're being dealt with internally. They're being handled appropriately. You're following our kind of advice. But a good more than 10% have had to have the Ministry of Labor involved, and we've seen that employers who deal with these things, in good faith and compliance with the guidelines, have had some success, considerable success, with the Ministry of Labor on these kind of issues. The Joint Health and Safety Committee, again, an old chestnut established by the Act decades ago to discuss safety issues. It's a rep for smaller workplaces where it's just one person. It involves, we suggest you involve the Joint Health and Safety Committee in the planning process for developing COVID-19 protocols, consider meeting before the workplace opens electronically via means such as we're doing now. The Joint Health and Safety Committee has the power to recommend solutions, but cannot impose decisions. I mean, there's going to be some members of the committee that think they're part of management, right? You'll always still have those kind of folks, and there's, I applaud their enthusiasm, but at the end of the day, it's sort of a misunderstanding of what their role is, which is management manages, the committee recommends. But that being said, the mineral inspectors, one of their standard things they do is review Joint Health and Safety Committee meeting minutes, because certainly if there are issues in the workplace and reasonable recommendations are being made and ignored, that's an alert to the Ministry of Labor, that something needs to be done here. The Joint Health and Safety Committee is an important part of assessing what is reasonable. Be prepared, especially in this COVID environment where we have sources all over the place, sometimes at the highest levels of government in some places, that are recommending dubious methods for cures for COVID-19 without naming who that is. That's just one example, but sure. I mean, we know the internet is a dubious source for research sometimes at the best of times, but COVID has magnified the fake news, so to speak. There's all kinds, and also, of course, there is legitimate disputes even among academics about the efficacy of things, and we've seen advice evolve, right? NASA is an obvious example. At the start of the pandemic, there was certainly considerable noise from credible sources that there weren't of any benefit. Now they're considered a blanket requirement. So at the end of the day, I mean, you have to bear that in mind. And you may, it may also be helpful to have your committee members retrain on what the role of the committee is. Many of them, especially in office settings, are probably not used to dealing with contentious safety issues. That's kind of the low, because offices are generally a pretty low risk environment. And, in terms of when you're really thinking about guards on paper cutters and how fire drills work are usually the main things in offices. Now, it may be useful for those that aren't used to dealing with serious health and safety issues or high risk health and safety issues to sort of get some retraining done on what the Health and Safety Committee is actually meant to do. Hazard assessment. This is, I mean, again, this is one of the trickiest things. It has to be balanced against privacy and operational concerns. Efforts that need to be made to assess hazards. Those things should be documented. So you want to have a paper trail. I know every lawyer tells you that, but in health and safety, it really does matter. The verbal is not as helpful. I want you to remember something that from health and safety legislation that comes out of a case that is now almost 10 years old, the Court of Appeals, Sheehan's Truck Center. But basically, what the court clarified what the actual standard is, what OHS legislation seeks to do. It seeks to provide a reasonable level of protection for workers in the workplace. It points out the law does not require entirely risk-free work environments, thankfully, and that's it. Like when we're talking about COVID, we're talking about managing but not eliminating the risk. The only way to eliminate the risk is not to go to work at all, right? I mean, at the end of the day, that's it. But you always want to. But I think what Sheehan's reminds us is we want to prioritize hazards and address the highest risk items at the outset, and then work our way down. And there's a lot of publicly available information from government and elsewhere about how we can, in good faith, manage the risk. So let's take a look at the kind of dispute, the kinds of disputes that we're seeing out there. This is one of them. The Joint Health and Safety Committee at a single location of a large national retail store recommends to management that only 10 customers be allowed in the facility at once. The store has paid for an analysis, a big national chain, the kind of things they do, from an expert that determined that it is safe to have up to 28 customers at once. Other facilities of a similar size in this chain are allowing 28 customers at once. What should the employer do? How would this dispute be adjudicated? Well, this becomes one of the trickiest things, right? Like it's one of the debates you're seeing in the education sector, right? Like we're having this number of 15 students thrown out there. I'm not suggesting the number is arbitrary, but is the risk that much different if it's 14 or 16? I can't imagine it is from a lay perspective, but either way, that's what's out there. So we have to recognize that there's a certain degree of arbitrariness in all this. I mean, it's just like whenever you set a number for something, whether it's what is the drinking age? Is there really a difference between 18 and 19? I don't know. But I mean, again, in the law, law and analysis, you have to set a number somewhere that makes sense. But there's a significant disparity here between the committee and and what the expert is saying is fine. So the committee really, I think, you really would dig back and say to the committee that, look, that we had someone. This is the report that we have. You have to share a report concerning safety with the committee. This is their analysis based on science that why this is going to go. And they're suggesting almost 3 times as many as you're suggesting. Do you have an incredible basis other than your own intuition or your just own sort of subjective belief that that would be easier to have 10 people in the store rather than 28? And I mean, at the end of the day, I think if you have an analysis that takes from a credible source that takes into account those things, that this is being done at yourself in similar numbers, I mean, at supermarket A and supermarket B, if it's pretty much similar to what they're doing, and that's the standard, it's going to be an uphill battle for the Joint Health and Safety Committee to say we should cut this by a third. But how this would ultimately be adjudicated if the Ministry of Labor would come in, they would make a decision as to whether the employer's right or the committee's right, or maybe even reissue an order to something else, and the party who's unhappy can go to the Labor Board and argue about it. At the end of the day, either by means of a work refusal issue or appeal of a refusal to issue an order, it ends up in the same place. There's a worldwide, obviously continues to be a worldwide shortage of PPE and cleaning supplies. I mean, that's being lessened somewhat, but as you know, cases pick up again, particularly south of the border, that we'll see how long that lasts. I put some employers in an almost impossible positions. I'm sure many of you have seen significant increases, of course, to costs of PPE, and I'm not sure I'd ever thought I would see the day that a bottle of hand sanitizer would be $25 for a 750 milliliter bottle. I mean, there's no way of designer cons, but I mean, again, but courts will place great weight on equipment recommended by the government, and certainly failing to provide recommended PPE is one way in which the government is one way in which you could find yourself in a situation where a work refusal would be upheld. So those are my comments on occupational health and safety. We're going to pivot over to Jeremy, who's going to start getting into the issue of the various government programs, starting with subsidies.
Right. So this is a program. This is the part of the program that we spoke about in detail on some of our earlier attempts. We've got an awful lot of sort of practical matters to deal with during this presentation today. So I'm not going to be spending an awful lot of time telling you about how to apply for the 75% wage subsidy or dealing with the CERB crossover with employees who are on layoff and things like that. I'm going to be talking more a little bit later about the employment consequences of these things, and as these programs change, some of the strategies based on what we've seen so far and what we're likely to see going forward to help you deal with it. But obviously, I mean, I've put together this little hedge maze here with all the different acronyms and alphabet soup that we've got. Some of you may have seen this in one of our earlier programs, but we've got our COVID Minotaur at the middle of the maze, and the various programs around it are all designed to help you in one way, shape, or form. Unfortunately, these in many cases were thrown together by the government just trying to provide support. And I think the intentions were good, but execution was lacking in a number of areas. And of course, there were a number of crossovers or issues that were latent that people didn't realize were going to happen until they were implemented in force. And so again, we don't have the time to go through the mechanics of these various programs, but it's important to keep in mind that the CERB was the replacement for EI, and as the entitlement of employees to CERB, which is the Canadian Emergency Response Benefit, the $2,000 that they get for a 4-week period, as that entitlement ends, they're going to be going back on EI if they're eligible. And that's going to have an impact on the other programs that employers are eligible for, whether that be the wage subsidy, which, again, we're not going to go into detail, but which has been extended until December, albeit on a modified basis. So now it's not 30% and you get, or 29% and you don't in terms of loss of revenue. It'll now be sort of certain minimum amounts that you may be eligible for, and then you can be eligible at higher levels for the subsidy depending on how much you have suffered losses year over year. Again, I'm not going to go into great detail about it, but these things are going to alter the analysis, and it's going to be much more fluid, I would think, over the next 6 months as access to these subsidies and eligibility changes through time. The wage subsidy survey that we've got here shows that roughly 2/3 have not applied. And I have to say, in my experience, what's been very strange to me is a lot of my clients that I know, because of just how integrated we as labor lawyers tend to be with our clients, I know that they have suffered 30% or more in terms of revenue. I know that they have engaged in headcount reductions as a result. I know that they have a significant number of employees who have drastically cut hours or who may be on layoff. And to hear that, and then to see that these statistics are at least on our small unscientific study, showing that a lot of employers are not engaging the wage subsidy, which of course is available even for employees, for employers whose employees are not working at all. You can still pay them that wage subsidy. And in fact, it's about $1,200 or $1,300 more over a 4-week period that the wage subsidy will provide than the CERB was providing at $2,000. So again, I see these numbers. They do appear to reflect the experience that I've seen, anecdotally at least, but I will say that there are a number of employers that might want to give some thought to supporting their employees through retroactive wage subsidy applications. The employees would simply have to repay the CERB that they received if the employer pays them a greater CEWS. Now, a couple of the sort of more practical issues I'd like to tackle now. Here's our survey on headcount and hours reduction. So we've got headcount and hours reductions at roughly 50%. I mean, this looks like an American election result here. Not much of a difference. I'm not sure what the margin of error is here, but it seems that we're about even. The ones who have introduced these headcount or hours reductions, the vast majority have not sought agreement or even an acknowledgement. So that's sort of interesting. We're looking at your colleagues on the call listening in. The vast majority, nearly, well, not nearly, 82%, did not seek any agreement. They simply unilaterally imposed these things. And I have to say, from my experience, the majority of those changes or layoffs or reductions were implemented before the government introduced a regulation that I'm about to discuss, which after the fact and retroactively made some of those lawful, at least under employment standards legislation, which prevented a lot of constructive dismissal claims. But I do find it interesting that the survey of our small group does bear out the experience and what we've been seeing anecdotally and in the news. I will also say that the hits just keep on coming. I'm blown away. I half hoped, although I guess I'm only ever cautiously optimistic as employer counsel, that the courts would take into account that COVID is a pandemic, is an unprecedented situation, and that the law that comes out in cases, even if they're not COVID related, but the laws that deal with employer conduct, that somehow that would seep back into the mainstream. That we wouldn't continue to see this issue of employees being coddled and treated like they can't possibly understand these incredibly complex contracts. You know, the ones that say when you're terminated, you get only employment standards entitlements. Just because they're not worded in the most optimal way, everybody who bothers to read them and can read English understands the intent of a clause like that. And the courts have, in the last 6 months, issued 4 decisions that I've listed here, but there are many others, where they have looked for new and creative ways to say that employment standards only clauses are void, and that forces employers out of the expected contractual liability and exposure that they thought was limited to employment standards into the common law, which during a pandemic, of course, includes an obligation for employees to mitigate by looking for work. But you could be looking at the difference between, you know, a few weeks of employment standards entitlements and many months, up to 24 for long service employees or very senior employees, months of pay in lieu of notice subject to a duty to mitigate. So when you have a contract that you think is enforceable and you're making changes during COVID, or you're initiating layoffs or hours reductions, and you're hoping that that doesn't trigger a constructive dismissal, but you're saying to yourselves, well, but even if it happens, we've got these ESA only contracts, they'll save us. We look at these decisions, which again, none of these related directly to COVID, but in every one of these cases, these sophisticated employers, I mean, this is Microsoft, this is Swigon, this is, like, these are not small companies, and the employers were still found to have, in some way, shape, or form, created a contract that won't be enforced, and they find themselves in common law territory. So when you're making these changes without agreement, which it seems the vast majority of employers are doing, give some thought to your risk analysis. And I would think that getting some legal advice on your contracts would be a good idea. I wrote heavy sigh there because we keep saying this to employers, and I hate to keep doing it. But as these hits keep coming, it's time, especially now while we're implementing changes in the workplace or contemplating them, to have those contracts reviewed. You want to consider not just offering employment standards minimums in those contracts, and this isn't a webinar about this directly, so I won't spend too much time on that, but there have been arguments that the courts are now seeming to be more receptive about, that there's something unconscionable, which is a silly legal term, which means we just don't like how it feels to see this happening. How can you possibly enforce a contract that requires employers to follow the law? That's just unconscionable, inconceivable. And so somehow restricting employees to what the law requires, what the legislature has deemed to be their entitlement, is unconscionable. So you may want to rethink how carefully you craft those, and you may want to rethink what you're including or what you're trying to exclude. Obviously, before the regulation that I'm going to talk about, we have some issues. So we need to talk about what the law, how the law works, and then how it's going to work given the regulation, and the regulation is coming to an end. I promise I'll stop burying the lead very soon. So absent an express or implied right, the current law holds that a layoff is a constructive dismissal. So if you've got a contract and the contract does not expressly say that the employer can implement temporary layoffs, then a layoff of any duration at all is, by definition, a constructive dismissal of that contract, and the employee can say, you have constructively dismissed me. The constructive dismissal works like this. The employer violates a key prong of the agreement, and then the employee has to decide, do I accept that unilateral change, or do I tell the employer I don't accept it? And if I don't accept it, am I going to continue to work despite the change? And if I fail to continue to work, will the courts hold me responsible, or at least deduct from my damages award what I would have earned if I had continued to work despite the change. That's the mitigation aspect of this. You must keep in mind that employment standards entitlements are not subject to mitigation. So if you've got an employee with 26 years of service, then they're going to be entitled to the maximums under the Employment Standards Act, which are 8 weeks of notice or pay in lieu and 26 weeks of severance pay, assuming you're a sufficiently sized employer. And none of that is subject to mitigation. If they find a job day one after a constructive dismissal, they keep all the money that they earn there. You don't get any benefit for that success on their part mitigating. Note that employees who agree to a layoff are not constructively dismissed, but only if the agreement is binding. So if you have a signed employment contract already that provides for layoffs on a temporary basis, then that's fine. The layoff is permissible. It was part of the employment agreement. If you are one of the employers that had employees sign off on a temporary layoff now, you have to make sure you provided some consideration for that. I know it's somewhat bizarre to say we have to impose layoffs because we're struggling financially. We still have to give employees something of value. It doesn't have to be significant. There's no law on what the minimum level of consideration is. 1 penny of consideration is technically consideration. So ultimately, I guess we'll see what happens if the courts start looking at agreements like that. But if all we've done is have employees acknowledge that we're going to do this, that may not be an enforceable and binding agreement. So you're going to want to have a lawyer give you at least some advice if you're going to implement an agreement like this in the hopes of staving off constructive dismissal claims to ensure that you provide that consideration and it'll be enforceable so you can avoid the constructive dismissal claim that you're trying to avoid. Keep in mind, in general, before COVID-19, before this regulation, 10% or more of a change is likely a constructive dismissal, and less is still possible. There have been cases with 3 or 4% was found to be sufficient. Employees may be required to mitigate by continuing to work. Again, we talked about that, but that depends. So in a circumstance of COVID, we have a lot of employees who are suggesting that when these changes happen, that might be a constructive dismissal as a way of objecting, but they're not actually saying, I quit and I'm going to sue you now. And the reason they're doing that is because there's enough reasonably decent legal advice going around out there, which makes it pretty clear. In a situation like this, where you have employees who are not being singled out, but these are nationwide global crises, and your organization is implementing this across the board without discrimination, it's much more difficult to argue that you shouldn't, at least while you're looking for another job, mitigate your losses occasioned by the constructive dismissal by continuing to work. Ultimately, that doesn't stop employees when they find another job or at some point in the future from suing for the difference between what they would have earned and what they earned while they were mitigating, as well as for any difference when they actually end up mitigating by finding a job if there's less pay. Now, employees who continue to work but don't raise an objection expressly, they don't say, I don't like it, but I'm going to work through it anyways. They don't have to say the words, I've been constructively dismissed, but I'm going to work to mitigate. But those who don't express that they don't accept these changes and continue to work, after a certain reasonable period, will be deemed to have condoned these unilateral changes. And so that makes the change enforceable, and it makes that contract revised unilaterally no longer a constructive dismissal. So these are all very important to keep in mind, but again, it's a very tricky thing to do, to impose this and get agreement and have it be enforceable. So I have to say the majority of employers, at least in our survey, appear to be sort of putting a blindfold on and walking into traffic and hoping it'll all work out. Thankfully, they were saved by our friend, the new regulation that came out. But even this regulation isn't a panacea, and it will come to an end. So let's talk about the Ontario Regulation 228. This is one of those regulations that came out that made a number of changes to the Employment Standards Act. The most important from our perspective here is that the employees are deemed retroactive to January if they were put on a layoff or they had any reduced hours because of COVID, and that's important. If it wasn't because of COVID, it was something else, technically they're not deemed to be on a leave. I don't think there's going to be a lot of fighting about that as long as these hours reductions or layoffs happened in March, I don't think we're going to have much of an argument from anyone. It's not COVID related. But assuming it is, they're deemed now not to be on layoff, but to have been on infectious disease emergency leave under the Employment Standards Act. You don't have a duty to continue benefits unless there's a contractual obligation to do so when someone is on a statutory unpaid leave. And employees are deemed not to be constructively dismissed if they've suffered a reduction in hours as a result of COVID-19. And so this was the government's response. It came on the eve of what would have been termination of employment created by statute that would have affected thousands of employees, if not more, across the province. And the reason is that employees who are on layoff under the Employment Standards Act, even those whom you have the right to lay off, for the vast majority of non-union employees, we're talking about 13 weeks in a 20-week period, and then the statute deems that to be a termination. It's no longer temporary, it's now a permanent layoff. And when that happens, there's no way to agree that it's not a permanent layoff. The statute deems you to be terminated. And then all of these employees would have been able to say, even if you could lay me off temporarily, you have terminated me, now give me my employment standards entitlements. And that would have been chaos, I think. And so just on the eve of that sort of 12-week mark, the government came out with this regulation deeming these things retroactively not to have been layoffs. As a result, the 13-week clock never started to run. If your layoff began in March, it never happened. And one thing, though, to keep in mind is it doesn't affect common law rights. So as is often the case in employment standards changes, unless it expressly in some way gives you a right to do something for all purposes, if all it says is we're defining something under the ESA a different way, or we're giving you a limit on what you're allowed to do, if you're allowed to do it, it doesn't mean for common law purposes you have the right to lay someone off. So technically speaking, even with this regulation, if you don't have the right contractually to lay people off temporarily, if you've imposed what is a temporary layoff, there's a risk that that still is a layoff and still may be a constructive dismissal from a common law perspective. Now, this is very, very important as we transition back in, is that the deemed emergency, that declaration expired July 24th. The government has not extended it. They may do so in the future, they may do so and do it retroactively, but as of now, as of Friday, September the 4th, the regulation which said you're on a leave, not a layoff, the regulation which said reductions in hours are not a constructive dismissal, that protection is gone, even under the Employment Standards Act. And so that is when the clock starts to run again. If you've not returned your workers to work, that is when, technically speaking, if there's been a reduction, those constructive dismissals will start coming back under the Employment Standards Act, even if they haven't come yet under common law. And of course, the most important thing to remember is that the deeming, it's not a choice you or the employee gets to make. The statute has deemed someone to have been off as a result of COVID, not because of business reasons, they were on a layoff, to actually be on this deemed statutory protected leave. And that's a job protected leave where you have an obligation to return them to work, to the same position if it exists, or if it doesn't exist when the leave is over, to another alternate position. And only if neither of those situations exist are you allowed to terminate their employment without it being a reprisal. And a reprisal could expose employers to retroactive pay. It could expose them to an obligation to re-employ that person. There's a whole number of very serious consequences to that kind of a finding. So I urge employers to remember, this is not an opportunity to clear house. This is not an opportunity to look at the low-hanging fruit in your organization or to right-size your business after the leaves are over. If you get claims, and this is something that we've already started to see some rumblings of this. Often employees will get a demand letter will come in from their a lawyer, not threatening to sue now for constructive dismissal, but essentially taking issue officially, formally, with the changes or the layoff that has happened and expressing that the employee intends to work to mitigate, but that a claim may be coming. So when you get these, you want to consider what it is you're looking at. So first of all, if it weren't for the courts singling out employers and changing the law for the worse, I would have had a little bit more optimism that the courts would look at these situations more practically. But what we've seen in the case law on interpreting contractual provisions, if that holds, then the courts may not be willing to say that a layoff that was deemed a leave under the ESA is also deemed to be not a layoff for common law constructive dismissal purposes, and that the employer didn't have the right to impose either, and both are a contractual breach and expose the employer to common law damages and awards. So I guess the thing to do is call your lawyer immediately when you get these claims. The thing to do second is to have a look at the basis for those reductions. And I think the thing to do always right now is not to terminate anybody just because at this point you have no work. Let's wait until the deemed statutory leave is over. If you have a layoff that's in place because you have no work, so be it. And when September rolls around, that is the time to reassess who's on layoff, who's not on layoff, and to determine who you actually need to be working. And to the extent you can, return people to work to their original position and follow the law. I wouldn't be doing any proactive terminations at this point. When the time comes though, and this is something Ryan and I, we debate all the time because it's just so frustrating. Every written demand letter that we've been getting these days through our clients, the employees council is saying, and you couldn't possibly expect this employee to mitigate during a pandemic. How are they going to find a job? There's just no work out there. And they say this almost as of rote, like there's no evidence backed up. They never provide us with a list of all the jobs this person tried to apply for, or the searching that they did and came up with nothing. And so what we've actually done is something that we've been trying to get our clients to do much more before COVID, but now especially, is do some of that job searching for the employee. So the employee's lawyer says there's no work available. You know what? Pay $100 to a job search company. We've got some contacts that we use in our firm when these come in as well, and have a one sheet put together with a list of the 20 jobs that are suitable, that are available, and that are in that employee's geographic area that they should be applying for right now. So if they get a job, fantastic. That's good for them and good for you. If they don't even bother trying, well, that's fodder for cross-examination during discoveries and will help significantly in that way. So now I'll pass the conch to Ryan to speak a little bit about the human rights aspects of workplace accommodation issues.
Wow. Some interesting stuff that comes out of the human rights world here. I mean, certainly this is back again. A lot of there's obviously going to be complaints. Human rights are a lot when it comes to employment is usually related to disability. But in recent years, we've certainly seen a lot of complaints, an uptick in complaints around family status, which had historically meant been interpreted fairly narrowly to mean, basically discriminate. They weren't a fan of your wife, so something bad happened to you, kind of situation, your spouse. But it's been broadened to include childcare. There's a lot of cases on that in the last 5-10 years. And certainly now in COVID, with the risk associated with the transmission of the disease, where certain particular types of people being vulnerable to it, senior citizens, those with certain underlying conditions, introduces a whole new way to look at human rights cases. So I'm going to take a look at a few scenarios just to sort of go through human rights and privacy issues. And this one particular scenario is aimed at privacy. An employee working in an office tower setting tests positive for COVID-19. There are 10 other coworkers that were in regular contact with this person. Appropriate precautions are in place. It's not a health and safety issue in terms of the OHSA. Can the employer require a negative COVID-19 test before allowing the employee to return to work? Should the employer at least inform the other persons who are in contact with the infected person? Should they inform everybody, send out an alert, that kind of thing? I think the answer to that question is employers have to be very careful when they're dealing with someone's confidential medical information, which actually includes a positive COVID-19 test. So answering the first one, I think, is fairly straightforward. I think an employer, at minimum, of course, can get the person to quarantine once they're better. But I think certainly, I take issue with them saying the person has a negative COVID-19 test. I think that testing is fairly readily available for people like that. Province of Ontario, I don't take issue with that. Secondly, should you inform the other people? And this is when you're dealing with confidential medical information. You don't want to do that. What you want to do is inform the local public health unit, who are the ones dealing with the contact tracing, and obviously you're going to provide a list of people that this person regularly is in contact with, who's ever on the floor, or however you define that, and work with let the public health authority deal with contact tracing. You don't want to be the person or entity sharing confidential information with other people. I mean, I know that there's a little bit, the reality of this a little bit is it's a bit of a fantasy in the sense, obviously everyone's going to know who it is. They're going to be contacted by the public health authority, but certain liabilities are triggered to an employer for breaching confidentiality. So even though it is a bit of an illusion, in this particular instance, you would want to go through the public health authority. Next case, and this is one that is actually based on a real COVID-19 arbitration decision that was made literally a couple of days ago. An employer operating a large plant on the border with Michigan, this is in Northern Ontario, has an employee who lives in the USA and commutes to the plant every day. The plant implemented a policy that, I won't get into the details, but it requires the person to live in Ontario for the duration of COVID-19. Regardless of the fact that the individual, has a residence in Michigan and they basically are saying you're going to have to live, and this person has childcare responsibilities. Interestingly enough, the employer is being stricter than the Federal Quarantine Act, which for most of you know means if you come into Canada and you've left the country, you have to self-isolate for 14 days, even if you're a citizen of Canada. But there is an exemption for people that live and work in one side of the border and commute to the other. That was mostly written with healthcare workers in mind, but it applies to anyone who does that. So legally, this person does not have to self-isolate under the provisions of the Quarantine Act. Rightly or wrongly, that's the law. So the union, this person has childcare responsibilities in Sault Ste. Marie, Michigan, where he lives. So the union filed a grievance on the worker's behalf, in which side was successful. The arbitrator went through, various factors, including looking at the level of infection, which basically was triple on the Michigan side to what it was in Ontario, but certainly not rampant like it is in the more urban areas of Michigan around Detroit and such. But still, it was a lot higher than it was on the Ontario side. But basically, the arbitrator decided that, look, this person's legally entitled to come into Canada and not self-isolate. Precautions can be taken to protect workers as it stands now. And so he basically allowed the grievance. Didn't allow any back pay. Basically said you got to take the guy back to work and not allow him to commute to and from the Michigan side of the border. So ultimately, I'm not surprised by that decision, really. I mean, it's hard to take a higher standard than the government's already imposing on individuals. So bottom line is I'm not particularly surprised by the outcome, but every case is fact-driven. And the arbitrator said, look, I mean, it may very well be that they may come back with, he may look at this again if all of a sudden, the rate of infections in Michigan goes far higher in that area of Michigan than it is now. So the final story hasn't been written, but it's a very fact-dependent analysis. But you're going to have an uphill battle on making someone quarantine when the law across the border says they don't have to. An employee, another scenario here, this is the family status kind of issue under the Human Rights Code. An employee has a child with an immune system disorder and has been working at home since COVID-19. The employer asks him to return to work in the office. The worker indicates he cannot because of the risk to his child, potentially the risk of him being exposed to COVID-19 by going into the workplace. The employer indicates that everyone is vulnerable people in their lives and instructs them in a very non-legal advice sort of way, and instructs them to return to work. The employee responds by threatening to file a human rights case. What'll happen? I think the employer's got an uphill battle on these facts, in my view. And the reason I say that is this person has been working fine from home, presumably they have been working fine from home since the pandemic started. All of a sudden to say that we need to drag the person back in the office, which would be our preference, but there is protection because of family status. It would be considered potentially discriminatory to require that person because of the risk to that person, and it's protected by the code. You have to establish that it's an undue hardship, which is a hard thing probably to do. I mean, unless you're in a certain sector, like certain sectors, for example, like education, where you're in a situation where working from home is not really effectively the same thing as working from work. Teaching a kid at home is not the same thing as teaching them in a school. I think anyone who has kids has learned that over the course of this. So maybe different workplaces have different realities, but for a standard, office worker who legitimately can do their work as effectively or fairly close to effectively, we know that in disability, we accommodate a lower production standard. It's an uphill battle to win that kind of an argument, and probably not one you want to embark on, because you have to remember human rights damages here. Like if the worker wins this argument, you're effectively going to have paid them to do nothing from the day they filed the complaint to the day the matter's resolved, which could take years. So it's a huge risk and a huge downside risk if you're wrong. And you're probably not going to be successful on this. And you certainly, if you think you're going to want to take an aggressive position, you want to get some legal advice first to see, like, really what risk are we really exposing ourselves to here to this person. And I know there's some frustration out there that this person who doesn't want to come back to work is running off to on their Facebook page, is running off to the beach and parties and restaurant patios and all the rest of it. But get some advice on it. Next slide. Let's use that same scenario, okay, with the person that doesn't want to go, the man that doesn't want to go back to work with the kids. But what if the person was an elderly parent who lived in the employee's home with no underlying health issues? Well, I mean, the underlying health issue, as Jeremy put it the other day, is the fact the person's old. I don't think it changes the analysis. I agree, it probably is. I mean, we start getting into medical things here. The risk is probably to the child with the immune system maybe higher, maybe it is, who knows? But the Human Rights Tribunal is not going to get down into the weeds and speculating that. If someone legitimately has someone who's old at home, and remembering, of course, the person's going to testify that they wouldn't let their kids bring their friends over, and that all the precautions, if they're being honest, that they're taking because of this person, an arbitrator is going to probably come down to the same analysis. What if the person in question was a close family friend considered by the person's children to be an aunt? And this just gets into the technicalities, right? Like, what's a family, right? I mean, ultimately, the person is, so it's not, it's not one of those kind of situations. But you want to, the bottom line is that it's conceivable the Human Rights Tribunal would say family includes someone who's not a biological family member. Again, the Human Rights Tribunal tends to interpret the code broadly, so making a technical argument on something like that probably not helpful. And plus, even just from the court of common sense, whether it's a blood relative or not, it's the same thing. What about a cherished relative with serious underlying health issues not living in the home? Again, we don't know where these cases are going to end up. That's one I think that probably the employer has a little more latitude here, because once you get into that, you're pretty much starting getting into almost everybody has somebody who for sure in their life is a senior citizen. Everything is fact dependent, but you never know what the Human Rights Tribunal will do. They've surprised me with how far they've gone before in the past, believe me. But on this particular one, I think the employer is probably in safer territory, just because the precedent is that it covers so many people that way that it make the it's at some point, even though the person may be able to work at home effectively, it's not. You can't use the Human Rights Code as a sword like that to push it that far, I don't think. But again, difficult to say for certain. You never know what they'll do. Next slide. All right, so this is an interesting poll number. How many people, of course, shifted all or part to remote working? Again, that's 80 some odd percentage of you, which could be just a function of the demographic who's listening today, but that's certainly been our experience in any kind of business that's sort of office-based, where you're not physically making something in a facility, which you can't really farm out to working from home. But people have, and how many people think it's going to increase after the pandemic? Continue. A good half of you say it's not. So clearly more than half of you who responded said, look, we're going to go back to normal here. This is a temporary situation, probably not ideal for any number of reasons. And then some of you say, hey, this is great. There's going to be some, hey, maybe we can reduce our overhead costs. I mean, certainly some landlords might be looking for tenants in the not too distant future. So those are my comments on human rights. We're going to shift it back to Jeremy, who's going to get into the thorny issue of sub plans and work shares, which is a very technical item. So let's hear about that.
Thanks, Ryan. So one of the things that I was doing in March, an awful lot, I would say March and the beginning of April, was helping employers with work sharing and sub plans. So a sub plan is a supplemental unemployment benefit plan. It provides for top ups over employment insurance benefits to allow employees to suffer less when they're put on a layoff due to no fault of their own. And the work sharing, of course, is a program that Service Canada has also had for years, which enables employees to access employment insurance benefits even when they're not on a full layoff. So it allows the employees to share work that is available at their employer, and EI pays them for part of, at least, the difference in terms of the loss, even if they're not suffering the typical 60% reduction that would trigger their employment insurance ROE and entitlement. But when we look at this survey of our small little subsegment of the economy, I actually think these numbers are probably pretty accurate based on, at least anecdotally, what my clients have been telling me and what I've been seeing with my colleagues. An awful lot of companies put sub plans or work sharing plans in place in March, or applied for them in March and April. And then when the Canada Emergency Wage Subsidy came out, the 75% subsidy, the math just wasn't there anymore, right? So if you can get from the government roughly the same or more to have people either at home or working as work becomes available, then to put them on work sharing programs or to just put them on the sub plan dole, then it's better to do that. In some cases, by $1,000 or more in the employee's pocket, and much more fluidity for the employer. And so some employers just weren't familiar with these programs or weren't comfortable signing up for them. Others did the math when the wage subsidy came out, and because their business had been affected, either 15% in March over March or 30% thereafter, they saw a net benefit to the wage subsidy instead. But now that the wage subsidy is going to be removed, it's been extended until December, but you're going to see a lot less, I think, as the economy picks back up, as we transition back to reopening, a lot less businesses who are going to qualify for the full subsidy. And even at the lowered levels, we have to start taking more measured and perhaps proactive approaches. So I want to take you through these programs again briefly. I know we want to save some time for the question period. We're a little over 1 o'clock, so I'll cover these fairly briefly. But essentially, a sub plan is the employer's top up, and it allows you to top an employee up to 95% of their combined pre-layoff earnings if they're on a layoff and they're in receipt of EI. And that's very important that the payments here are not insurable earnings under the Employment Insurance Act, which is a fancy way of saying it won't affect someone's employment insurance claim. That's the whole point of a sub plan. It allows the employer to give the employees a little bit extra because EI is only going to be giving them a small amount, and even at the maximums available, it may not cover their sort of daily expenses. A sub plan, a number of key issues. You have to think about how long it's going to be, what groups of employees will be covered. The reduction in hours can only, the layoff can only be due to a layoff, quarantine, or training. So you can't just provide a sub plan for every reason why an employee might be off and receiving employment insurance. But this should cover the vast majority. And then, of course, the plan duration and what percentage of benefits you want to cover. So you don't have to cover the employee the difference between EI and 95%. You can cover them up to a combined 75%. You can prescribe that it'll be up to a combined 75%, but in no case more than $300 a week from the sub plan. So these are all things that you can consider. Unfortunately, the government, I'm not sure if it was intentional. They wanted everybody on the wage subsidy instead, but they intentionally, I think by now we can assume, excluded sub plans from being able to pay out while people were on CERB as opposed to EI. So there were a lot of questions early on. A lot of employers started paying out of their sub plans, believing that employees were on EI, and they forgot to do what you have to do, which is to verify, get the employee to send you the information from their Service Canada portal to verify that they're actually on EI and how much they're getting. And so employees were getting the CERB instead, and you're not by law allowed to pay out under your sub plan if someone's on CERB. What it ends up being is just another payment that the employer is making. And if someone is receiving more than $1,000 from their employer during a 4-week period that they're receiving CERB, then they have to pay back that CERB to the extent that they're receiving more than $1,000. So unlike sub being paid out during EI, which is not EI insurable and so doesn't affect their EI claim, if you paid out of your sub or just paid out extra money to help your employees during their receipt of CERB, it will have that impact. They will have to pay back some of that money potentially. So do have a look at that and make sure your employees are aware they may have a repayment obligation there. You can, and this is one of the chief benefits of having a sub-plan, and this is the reason why I was recommending it to many of my clients, is that whether the employee is eligible or not at the time that they're signing on, you can have a schedule to a sub-plan, which I recommend an employer or counsel prepares for you. But you can have a schedule where they sign off and agree that in exchange, in consideration for the employer implementing this sub-plan, which again may or may not give them eligibility at various points in time, but in consideration for your implementing this plan, which is something of value, they agree that you can implement temporary layoffs within the limits of the Employment Standards Act without that being a constructive dismissal. So going back to those earlier slides, this is a way to ensure you have consideration for an agreement that wasn't part of their contract, that you can implement a temporary layoff. So this is important because that applies to both employment standards and common law when you get an agreement like that with consideration. And also once the regulatory deemed leaves are over and people start going back on layoffs and those clocks start again, well, now you have that issue poked back up. Now all of a sudden you have a risk of constructive dismissal claims, not only under the common law, but now under statute as well. And so that's something for employers to consider. Work sharing was also, again, a program that's been around for a very long time. Many companies found that work sharing wasn't necessary if they were eligible for the CEWS. And of course, that's because if you can have an employee receiving CEWS, or you can pay them 75% of their wages up to the applicable maximum, even to sit at home, and then you get your EI and your CPP premiums back as the employer, why bother with work sharing? They're going to have more net, and you're going to have more flexibility net if you just engage the CEWS. That wasn't the case for all employers. A number of my clients did have, our clients had us help prepare work sharing plans, and the government was pushing this, at least initially, as a significant area for employers to look into to avoid layoffs, to avoid constructive dismissals, to avoid work reductions, and of course to minimize benefits that the government was going to have to pay out. Essentially, a work sharing program, for those not aware of it, provides EI benefits for part of the difference. So as an example, let's say you have 20% reductions, people are going to start working 4-day weeks. Everyone across the board has to accept a 20% reduction if they're in that work sharing subgroup. And then as a result, what we have are reductions for everyone in that work sharing subgroup. So you have your umbrella plan, and then you have subgroups, and everyone actually has to agree. If they don't agree, you can't have some people who should be in that group not included, which is a holdover from ancient times, which remains part of the requirements. I'm not sure if they're ever going to eliminate it. It still hasn't been eliminated even now. And again, the employees get some employment insurance to cover that net difference of the 20% to the applicable EI maximums. So very quickly, work share units should include complementary employees. They don't have to, but it's helpful because you don't want employees who shouldn't be working at different times or shouldn't be working in complementary roles to be sharing the same reduction unless you can manage that and orchestrate that from a scheduling perspective. It used to be that senior executives and those who were supposedly leading the charge on recovery weren't eligible. That's not the case during COVID. The government hasn't said when they will return it. So it is possible to apply for that at this point. It used to be you have to have a recovery plan that was quite detailed, and the Service Canada folks would review it with you before approving your plan. Now that's been reduced to a single question, which every client that I have is simply answered by saying, we're going to survive COVID, and when COVID is done, then we're going to come back out of our holes. And essentially that's been accepted by Service Canada. Everyone knows that we're all just fighting for our lives at this point, literally and figuratively. The agreements used to be 38 weeks. The government immediately in March extended that to 76 weeks as your maximum work sharing plan. But the way that it works is the reduction is an average over the duration of your plan. So you just have to manage those hours. Sometimes they'll get a little bit more, sometimes they'll get a little bit less. And ultimately the question is going to be, what was the average over time? And it simply can't exceed the amount that was agreed to. So the plan will start now within 10 days of the application. It used to be 30, now it's 10, although in my experience, it is taking them a little bit longer than they hoped to get that information to you. This is really some just very basic information here about eligibility. I won't go into it, but suffice it to say that these programs take time to apply for. Some of them, depending on what you're trying to use them for, can be a bit complex, and it will take time to get applications approved. So if we're now into that transitional phase, now is the time to start looking at these programs again, dust them off the shelf if you've already made an application, perhaps make a new one, or call your counsel. We'd be happy to help you to work your way through these. So now we're going to get to the Q&A. So I guess I'll ask Ryan to rejoin the video there, and I will, I guess I will dole the questions out as I go through them. We do have quite a few, and we do have limited time. We'll try to get through the questions. First, as always, the first question always seems to be, will we get a copy of the slides? And as always, the answer is, following the program, we will send out a survey soliciting your feedback. It's really a very short survey. At the end of that survey, which helps us significantly to make these programs better, you will be directed to a link which will take you to our site, where we will have a link for you to download the slides from the presentation. So that's sort of our thank you to you. We give you the slides, you give us your feedback. There's your consideration. Now we can lay you off. So Ryan, here's a good question for you. A worker is not refusing to work, but is not prepared to go into the physical workplace as he has family obligations, and currently schools, camps, daycares are closed. They have 4 children and they're a single parent. Work continues to threaten her and asks her for justifications why she can't come in. So she's saying, I don't wanna, and they keep saying, well, prove it. Show us why you can't. Actually, here's an added one. You'll like this. Apparently her productivity increased while she was working at home.
Okay, well, it sounds like those were actually the facts that were able to be established. I think the employer's going to have a hard time with that. I mean, you know, it's a unique situation. It clearly is covered by family status. It's clearly as someone who's, if she can establish she can do the job from home, it's not likely to be an undue hardship for the employer. I mean, I think that it's not entirely different than the scenario that we went through in I think the employer is going to have a rough time with that argument, assuming that, sometimes people measure productivity differently, of course, but, I think that's with 4 kids, and then I think with the way things are, I think it's going to be a tough
battle. So here's an interesting question. This employer has a sales force that are working from home, but it says here that a significant proportion, I gather, of their compensation program includes a kilometer allowance per business kilometer driven. And because they're working from home, they're not receiving this kilometer allowance anymore. So, I mean, I guess, why don't we talk about that sort of brass tacks? First of all, it sounds like the amount of allowance is based directly on the expense. So the actual kilometers driven. So this isn't an allowance so much as it's a reimbursement at a set rate. So I'm less concerned for this employer about a constructive dismissal claim, because these employees are not being compensated, they're being reimbursed. And the level that you've set that reimbursement at might be a little bit enriched because you see it as a bit of a compensatory element. But it's really not. What we're saying is the government's 50 cents or 54 cents isn't good enough. We're going to pay it at $1 or something like that, because we recognize there are more costs than the government tax guidelines are accounting for. On the other hand, if what you've done is provided employees with something that is truly an allowance, so let's say you currently have employees not visiting any of your customers directly, and you provide a vehicle allowance, or you're providing them with a gas card, but they're not using any business use, all their spending must be for themselves. That is much more clearly, in my view, a form of compensation that you're not tying directly to an actual cost that you're reimbursing. If you were to eliminate that during COVID, there would be a much quicker path to victory for an argument that if it is significant overall, it may be a factor in determining what is and what is not a constructive dismissal. Of course, if the overall effect on compensation is negligible, then it's probably not going to be enough. Sorry, just bear with me, guys. I'm reading through a number of questions here. I guess this question might also be for me, though. An employee uses vacation time to travel, but is required to quarantine on their return from home. So, you know, they've traveled abroad, they have the 14-day requirement now to quarantine, but they've used up all their vacation time. What can the employer do? Well, they're required by law to self-isolate for 14 days, so they are now on infectious disease emergency leave, or whatever you want to call it. They're on a job protected leave for 2 weeks. That's not a paid leave. That's just a leave that's required by law, and you're required to give it to them. The problem, of course, is that, well, twofold. You're not required to give them that time without work. You're required to give them that time not coming into work. So if they are able to remotely work, you don't have to give them that time as unpaid leave at all. You can pay them for their services. If this is work they can't do except from the office, then you have to give them a leave, and they have to take the leave, and you can require them to take the leave, and you don't have to pay them unless your contract provides that you do. So if you've got a contract that provides that employees who are on a self-isolation or quarantine will be paid some amount under a short-term disability plan or whatever sick leave plan, then you might have to give them sick leave. If your sick leave or your short-term disability plans do not provide for pay in these circumstances, well, then they're off on and they're unpaid. So here's a question for you, Ryan. What could happen if someone is not effective working from home, but still insists on working from home once the office is reopened, and they try to put forward an accommodation request? How do you balance performance and accommodation?
All right, well, that's the age-old battle. I mean, it's the same sort of analysis you sometimes run into with disability accommodation, where you have somebody who's disabled, but you're also trying to manage a performance issue at the same time that's not related, in our view, not related to the disability. So first and foremost, the person, what is the accommodation, right? I mean, certainly, let's just take, I mean, certainly the one that's going to come up most of the time is I have kids and all this sort of thing. Although, I mean, we'll see what happens with the provincial school announcement. That might make a difference. But I mean, accommodation is not about accommodating a preference, right? Like when you look at like sort of the motherhood cases that come out on family status with this, I mean, the one that really was sort of the trendsetter was 2 border guards working at the airport where they could be under their agreement assigned to work at any time. They both worked for the same employer. One of them wanted fixed shifts essentially to, so they had some certainty for their kids. If there's someone else who can look after the kids, and there's some other service, that it involves a financial cost, you don't necessarily have to accommodate it. You are entitled to information, and you're entitled to push back. And secondly, even if the person thinks that they're working effectively from home, it's management's job to manage. So if you have a bona fide reason to say it's more effective to be in the office, or we'd rather you, that's your right to do so, subject to human rights limitations. So the way you balance it is you get some information from the employee as to why it is, assuming it's childcare, that they simply cannot come back into the office, remembering that they certainly managed their children before COVID-19 with this. So it's got to be something COVID related. And if the kids are back at school, that's a much harder argument to make. And if they had someone who's looking after them previously, if they were younger than that, why can't they do that now? Those are all the questions I'd have. I certainly wouldn't just carte blanche accept every one of these by any stretch.
And for what it's worth, the individual who asked that question, this has been a perennial problem at that company, and my understanding is that to date, before COVID, they had a very strict, we don't like telecommuting telecommuting policy. It was just generally frowned on and not allowed. And there's actually been a little bit of litigation where employees at that company were permitted by certain supervisors to work from home at various times and weren't told that those were temporary arrangements. And then the employee later asserted that was actually now part of their contract and they couldn't be ordered back. So that is probably the case for a number of the folks on our call. But I think, Ryan, your comments are apt here. We can't look at the old tests and the old criteria. We have to consider this in context, and we have to be, I think, out there getting the information we need to determine today what we have to do. So that's sort of, I just noticed who it was that asked that question. So hopefully, yeah, they'll have a smile on their face right now. Here's another question for you, actually, Ryan. Are you legally obliged to pay an employee who you ask to self-isolate as a safety precaution?
Well, I mean, ordinarily, no. I mean, you're ordinarily, as Jeremy mentioned, there are certain statutory protected issues under the ESA for someone who is at least under a government leave, but no, you're not obliged to. You're not typically obliged to pay them unless there's where the issue comes up is that if it comes back to all the stuff that Jeremy was talking about, as to whether the person says, hey, you have no legitimate reason to lay me off, and I should be allowed back at work. And that sort of comes down to similar to the border case, for example, where that we talked about, where the individual was allowed to cross the border and work legally in Canada, was exempt from the normal self-isolation, but the company said, no way, Jose, we're still making you lay off anyway. In that case, the arbitrator said, no way, Jose, you're paying them. At least making them come back to work. So it's a very fact-driven exercise. In the non-union environment, that person could take the position that you're firing them, because you're not allowing, if there isn't a legitimate reason for them to be self-isolated. And it comes down to, why are they being asked to self-isolate? Is it a layoff? Is it a layoff and dismissal or not?
Yeah, it's nice to know that at least for now, the law still makes a little bit of sense, Ryan. Well, here's an interesting one, Ryan. Does getting into the workplace itself, I assume that's what this question is about, count when looking at work refusals? So what if someone would be willing to come to work, but they refuse to undergo temperature testing or whatever else it is, and so as a result they're engaging in a work refusal? They think it's unsafe to come into the office.
In my opinion, the phrasing of that section, and this comes up, right, because people worry about, like, well, the crowded subway is a rather potentially, even with the mask requirement, a hazardous issue unless people on it. But the work refusal provisions of the Act nearly answering question, my answer is no. The TTC car is not a workplace, so it's not, the commute is not contemplated by the Occupational Health and Safety Act.
Now, I guess from a practical perspective, and at least my experience has been with even with our own office, our office is downtown Toronto. Most of our employees come in using public transit. We've tried to minimize their exposure in that way, even though there isn't technically a legal obligation to do it. We've tried to minimize the obligation to come in, except where it's sort of necessary to do work. But ultimately, it goes down to the difference between whether this is a reasonable precaution that's required by the law, or whether it's just simply something you can and so you do.
Yeah, there is some comments. I mean, the question was aimed at whether it's a work refusal provisions apply, but I mean, in terms of like whether you stretch it to say that the jurisdiction of the Act extends that far, maybe, possibly. The guidelines seem to say it does. It's one of those. It comes down to whether that's part of the workplace or not. It's a very technical, it's one of those things, but as I always said, it's better to be practical than technical when you're dealing with health and safety legislation. So irrespective of whether, to me, it's pretty black letter, the work refusal provisions don't apply. It is not so black letter about whether or not the Ministry of Labor can issue precautions and require you to stagger your schedules or whatever. I would encourage you not to get into that. Let's try to, be practical, not technical.
Okay. Just reading a couple of these questions that I'm looking through right now are a bit specific to the individuals, so maybe we'll have to follow up with them after the program. What about reversing the concern? So you've got the employee taking the TTC to work. The TTC, if someone's taking it, on a crowded subway, they're perhaps more likely to get COVID as a result of that exposure. And the WSIB, of course, is now deeming, until proven otherwise, employees who appear to have contracted COVID at work to have contracted a workplace illness, and so be eligible for coverage. Is there any concern with that overlap, given that the WSIB may allow some of these claims?
Yeah, I mean, I think at the end of the day, the bottom line is that if someone gets COVID-19 and they're working all day and they're commuting to and from work, I mean, it's going to be hard to say that you're avoiding a workers' comp claim. I think it's an inherent risk. Although the reality is, though, I mean, I hate to get into the dollars and cents of all this, but that's, you know, that's part of workers' comp. Most of them aren't going to be very expensive claims. Like most normal, healthy people who contract COVID recover from it in a relatively reasonable period of time without after effects that are going to prevent them from returning to work. So, I mean, if this we're talking, I mean, unfortunately, sometimes in life you just have to take risks. And if you're going to have people taking the subway, even though for the purposes of clarity, commuting to and from work is not covered by workers' comp in terms of entitlement. But if you can't, but again, you're not going to necessarily show, you know, you would have to, it would be on the rare case where it's an expensive claim that would be worth litigating. That's where you get into an investigation, whether there's any basis to say, hey, this person was at a nursing home with so-and-so where there's an outbreak, or some other legitimate suggestion that they could have got it elsewhere. Because if they didn't, yeah, you're stuck with it, I'm afraid.
Well, thanks, Ryan. We have a couple of questions that ask about some specific orders and whether those orders have been extended or amended. The COVID-19 information page on our website has links to a number of those resources. I haven't looked in a while to see if the page that deals with the orders that are continued or extended is specifically added as a link, but I'll make sure that gets added when our conference is done. So thanks to everybody. We've reached our time. We do like to try to keep these on time. Thanks again to everyone who responded to the survey. I think it provided a lot of context very helpfully to your colleagues and in the HR field, and to us to help us make this presentation, I think, a lot more impactful and useful. So again, thanks very much, everyone. Stay safe, and look forward to seeing you next time. Take care.